G'day everyone and welcome to video 4.1.6 for the Legal Studies Guide. Our quote today from Benjamin Franklin, famous American: "By failing to prepare, you are preparing to fail." I imagine many of you are reading this or listening to this at a time when there's still a few weeks before your next assessment or before the exam, etc. Obviously it's great that you are preparing. You're doing the preparation now so that you can succeed. And that's essentially what this quote talks to, making sure you put the steps in place, put the plans down to succeed. Otherwise, if you just go ad hoc and think it'll happen, you are going to fail. So as I said, we're at 4.1.6 today. And again, it's about a High Court case. This time, the significance of a High Court case, which has had an impact on the division of lawmaking powers. So one that's impacted what the states versus what the Commonwealth can do. So one that's maybe moved the boundaries of that a little bit. Again, we're discussing the significance of cases involving the interpretation of the Constitution. So our essential question: what happened in one High Court case involving the division of lawmaking powers? Just a reminder again that when we talk about cases in answers, we need to use this acronym FLDI. Briefly summarise the facts. What is each party claiming? What is the exact legal issue at hand? What decision does the High Court make? And then importantly, what impact does this have both immediately and into the future? So the case we are going to look at is R v Brislan from 1935, sometimes also just known as the Brislan case, which you can use either in your answer and the examiner will know what you're talking about. The Brislan case is obviously about the division of powers, which is why we're learning it now. And obviously those specific powers that the Commonwealth can use, be they concurrent or exclusive, are listed in Section 51 of the Constitution. So Section 51 of the Constitution: the Parliament shall, subject to this Constitution, have power to make laws for the peace, order and good government of the Commonwealth with respect to, and we are focused on Section 5 here. So the Commonwealth Parliament has the power to make laws regarding postal, telegraphic, telephonic and other like services. And I want you to take a moment now and just have a think. Postal, telegraphic, telephonic, and other like services. What does like services mean? Like, what is included in that term, that wording? Have a moment to think about it. And in a minute, we're going to go through the case and the particulars of the case, and we're going to find out what the High Court says like services mean. So here are the facts. Back in 1905, so we're only 5 years into the Commonwealth of Australia, the Commonwealth passes an act called the Wireless Telegraphy Act. So we're thinking, at this time, radio signals are pretty fancy. They're new. There's no internet. There's no TV. And obviously a lot of important communication happens over the radio. So the Commonwealth says if you want to have a wireless radio, you need to hold a license. You just got to have a license. Pretty simple. We fast forward until the mid-1930s, and the defendant, Mrs. Brislan, has 5 wireless radios, but she does not have that license. So therefore she's charged and convicted. Pretty straightforward. The law says you need a license to have a wireless radio. She doesn't have a license. She's charged. However, she decides to claim that this act, this Wireless Telegraphy Act, is not valid. So she decides to take the Commonwealth to the High Court and say, you can't charge me because you don't have the power to make this law. So what is the legal issue at hand? And obviously this is not from 1935, this picture. Pretty straightforward. The Commonwealth defends themselves and says, we are able to make this law because wireless radios are a like service. Okay? Postal, telegraphic, telephonic, it's all about communication. Wireless radios are that as well. We can make laws regarding it. The defendant goes a more literal interpretation and says, Wireless radios themselves are not mentioned in the Constitution. They are not stated. Therefore, they are left to the states to legislate on as an area of residual power, and the Commonwealth cannot make their law. Therefore, I can't be charged under it, and I do not have to pay the fine that you have made me pay. What does the High Court decide? This is the decision. This is the direct quote from the High Court. The common characteristics of postal, telegraphic and telephonic services is, in my opinion, to be found in the function they perform. They are communication services. This is also the characteristic of broadcasting service in all its forms, which is therefore, in my opinion, a like service. If a new form of communication should be discovered, it too might be made the subject of legislation as a like service. AKA, the High Court interpreted that wireless radios are like services and therefore the Commonwealth is able to make law in that area. What's the impact? Well, obviously immediately the Commonwealth law remains valid. Mrs. Brislan can be convicted under it. She has to pay a fine, or I think she could have gone to jail for 3 days as well. But what's the further impact? Well, essentially, and here's a key word you want to use, the further impact is it broadened the interpretation of like services to include anything to do with communication, which therefore broadens the power of the Commonwealth. So how does it impact the division of powers? The Commonwealth is gaining more power because like services has been interpreted in a broad way. Further on, it is now assumed that the internet is covered by this section, as well as things like TV. Hence, the federal government is able to legislate and regulate the National Broadband Network, the NBN, because of the interpretation of like services by the High Court in 1935. We've looked at this skill before. We are discussing the significance of High Court cases. So this is a sample question, and I've literally ripped off the question from the VCAR sample exam about section 7 and 24. And said, referring to one case, discuss how the High Court has impacted on the division of lawmaking powers. So 5 marks again. We are loosely considering that facts, legal issues and decision are probably worth 3 marks, a mark each, getting those right. And then the impact is worth 2 marks, so making sure we do the impact properly. Here is a sample answer. In this sample answer, we have the facts and the legal issues. So, one case that had an impact on the division of lawmaking powers is R.B. Brislan, just an intro. The facts. Mrs. Brislan owned several wireless radios without a licence, which contravened Commonwealth law. She claimed the Commonwealth was acting ultra vires. This is a great term to learn. Ultra vires means beyond power. So she claims that the Commonwealth is acting ultra vires. She claims that they are acting beyond their power. They do not have the power to make laws in this area and could not restrict her ownership of wireless radios as they are not mentioned in the Constitution. The Commonwealth, on the other hand, claimed that they could, as a wireless radio was a like service to postal, telegraphic and telephonic services, which were all listed in section 51. Decision. The High Court was required to determine the meaning of like service and passed judgment that the term should be read to include anything relating to communication. So just stating the decision, a mark there, and then the impact. And this is where we obviously have the most detail because it's the most important section. This impacted on the division of powers as it confirmed that wireless radio legislation was Commonwealth power, meaning it was a concurrent power rather than a residual power. As well as this, any communication devices that are developed in the future, such as the internet, are now considered to be subject to this interpretation, allowing the Commonwealth to legislate in this area. Probably a term that I've missed there that would make this answer stronger would be to say that therefore this broadened Commonwealth power. However, important to make sure I'm discussing, however, states can still legislate in these areas provided they're not in conflict with any Commonwealth law, because they are concurrent powers. They don't become exclusive powers. Concurrent powers provided that the state legislation does not conflict with the Commonwealth legislation. Some links. You can look at an explanation of the role of the High Court at this website, lawgovpol.com/constitutional interpretation. And here's a really good one to Google, and again, I'll post the link below. So Engage Education Wiki. So this is from the old study design, but the old study design had some High Court cases to look at as part of Unit 3, Area of Study 2. So this website, if you go to it, has both the case we're doing in 4.1.7 and this case and a couple of other High Court cases that you can watch some video lessons on as well that are a little bit short and might further your understanding. Ultimately, after watching this, I would hope and assume that you can answer our essential question. You can explain what happened in one High Court case involving the division of lawmaking powers, including, importantly, the impact of that. So who gained more power, who lost power, what changed, okay, what was broadened, what was narrowed, etc. This has been another video for the Legal Studies Guide. Do all those things. Connect with us on social media. Subscribe on YouTube. Like, comment, rate. And we'll see video 4.1.7 soon.